Hello and welcome to What It Is, a place where we talk about the ways U.S. immigration laws affect everyone. Today, we're going to answer the question, what is labor certification? Hi, I'm Michael Ruttle, immigration attorney and founder of Ruttle Law PC based in Torrance, California, where we practice immigration law in all 50 states. So what is labor certification? It's the first step in a long process of getting a green card through a job offer. It requires a U.S. employer to obtain confirmation from the Department of Labor that there are not enough U.S. workers willing, able, or qualified to do a job being offered to a foreign worker. That's what it is. The benefits from this labor certification process are twofold. First, it allows foreign workers who are highly skilled or highly educated to receive a job offer and have the possibility of immigrating to the United States with a green card. Second, labor certification allows employers to fill important positions that might otherwise go left vacant, thereby affecting their business. In order to convince the government that there actually is an insufficient number of U.S. workers able, willing, or qualified to do the job being offered, the employer must first offer that job to somebody who's either a U.S. citizen or a lawful permanent resident or otherwise qualified to work legally in the United States. This is done through a very specific recruitment process that's required under the immigration laws. Under the Department of Labor's process for labor certification known as PERM, at a minimum, the employer is required to place 2 Sunday advertisements for the job in newspapers of general circulation. The employer must also post a 30-day job order with the state workforce agency, usually a state government agency, and the employer has to post the job internally for 10 days. If the job being offered is considered a professional position, which is defined under immigration law, the employer must conduct 3 additional recruitment steps to what I just mentioned. For example, radio advertisement, placing in a professional journal, placing on a career website like Indeed.com, advertising on the employer's website, among others. 2 key things to remember with labor certification recruitment is that the employer must offer the job at what's called the prevailing wage, and the job description posted must list only the minimum requirements to do the job. So, with respect to the prevailing wage, that basically means that the employer can't use immigration law to hire cheap foreign workers. So if the job being offered has a prevailing wage of, say, $75,000 per year, then the employer must pay at least that wage and no less. With respect to the minimum requirements for the job, the employer can't post a job description that's so complex only one person on earth can do it. For example, jobs that require foreign language skills or other highly unique talents might lead to the Department of Labor starting an audit to see if the employer is recruiting in good faith. This can add significant delay to the process because the Department of Labor will come and look at internal records, delaying the process. Once the employer has engaged in the required recruitment steps for the job, and assuming no workers are able, willing, or qualified, then the employer can electronically file the labor certification application with the Department of Labor. The filing of this application is time sensitive, very time sensitive, and must be coordinated with the required recruitment steps to make sure everything happens smoothly. So it's ideal to have an experienced immigration attorney help you along the way who's familiar with the labor certification process. Some final thoughts on labor certification. First, it's important to know that in most cases, labor certification cannot, I repeat, cannot be expedited. However, there are certain professions such as physical therapists, certain performing artists, and among others who might be eligible for a process known as special handling, which might expedite the process, or speed it up, should I say. Second, even though the Department of Labor promises to issue a decision on a labor certification application within 45 to 60 days, they may select an application for an audit if they find that the application is problematic or if it's randomly selected. An audit can result in a delay of more than a year easily. Third, not all green cards obtained through employment are required to undergo the labor certification process. Persons of extraordinary ability, outstanding professors and researchers, multinational executives and managers, and foreign investors are not required to obtain labor certification, assuming they qualify under one of those categories. There's also something called the national interest waiver, which we will discuss in another video, but that also allows the foreign worker to forego the labor certification process. If you are successful and you're able to get through the labor certification process, then congratulations. You only have 2 more steps on your journey to get your employment-based green card. The next step is the employer filing an immigrant petition with the U.S. Citizenship and Immigration Service. That is followed by the worker filing what's called an adjustment of status application. The labor certification process can seem overwhelming. So if you're a foreign worker who has a job offer in the US, or if you're an employer looking to hire foreign workers for a specific role, contact an immigration attorney at Ruttle Law today to see if we can help you. Unfortunately, that's all the time we have for today. But hopefully you found this video helpful. If you did, hit that like button, click that bell, subscribe to our YouTube channel if you haven't already, and follow us on Facebook to stay up to date on the ways US immigration laws affect everyone. Until next time, I'm attorney Michael Ruttle. Keep climbing that mountain.